Today we're going to talk about estates in land. When we think about an estate, we tend to think about this large piece of property. But an estate can be any ownership interest in land. It can be the fact that you own just a part of something or you own the whole piece. But it can be a teeny piece of property to this huge estate. It doesn't matter. The estate is what it's called when it pertains to the piece of real estate. We go back in time, we look at the allodium form of ownership, which is absolute ownership of land where the holder owns no obligation to a superior. The allodial concept of private, free, and absolute ownership is a distinguishing feature of real property ownership in the United States. In other words, we don't have lords or kings and their underlings that own the piece of land where we're subservient or servants to those masters where we have to work the property for them and pay them part of our earnings or turn things over to them. That's a different form of ownership. But the United States, when it first created, we had, before it became the United States, we were under a different form of ownership. But part of our Constitution formed this allodial ownership where we have private and free absolute ownership. We don't have a master of our land. Feudalism is what goes back into old times, a system in which everyone holding the land owed rents and services to a landlord. There was tenure. The land was owned by the king but parceled out, and the tenants of land owned services to the immediate overlord. So again, in feudal systems, when you read the old romance novels and things like that, you learn about the people that actually owned the land, the lords and the people that had titles. Everybody worked for them or was subject to them. In the United States, we had early colonial land grants were based on this whole tenure process because we hadn't formed our founding laws to create the allodial concept. The surviving vestiges of feudalism is a sheet in which the state is paramount, with land reverting to it if a person dies without heirs. Obviously, if somebody dies without heirs, where's that property going to go? That dates back to this feudalism concept, and the land goes back to the state. So if you die without a will and they can't find heirs to your family, the state is entitled to the proceeds from the sale of the land, but they also have to maintain it until they sell it. So the English concept of estates and lands continues with the idea that separate divisible interests may exist simultaneously in the same piece of land. Yeah, we have multiple interests in a piece of land. That's what I talked about with mineral rights. We can sell off the lower levels of the underground piece. We can still own the piece of the surface, and then we can sell the air rights to somebody else or lease them. This visible interest. The other thing may be the fact that we have multiple ownership of this whole piece. So this is all this whole thing about the estates in land. So the estate. It's the extent and character of a person's possessory rights and interests in land. Estates actually have many dimensions because the real estate itself has many dimensions. A freehold estate. It's an estate of uncertain duration. We call it fee simple or fee simple absolute. It's the most extensive interest in land that a holder might possess. Very often, when we're selling residential real estate, we're doing this fee simple absolute. We expect that as we get title or we sell real estate, that we're giving somebody the right to be able to do anything that they want with the land within law, but they have the right to own this land forever until they die or something happens, but that's that uncertain duration. We have defeasible fees. It's a fee simple that terminates on the happening of some future stated event. So fee simple determinable automatically terminates when a stated condition is fulfilled, or fee simple subject to condition subsequent is an estate that may be terminated by the grantor or the grantor's successor when a stated condition is fulfilled. So if we donate a piece of land to a nature conservancy and they're going to continue to use that land, but then all of a sudden the nature conservancy runs out of money, they dissolve. They have to sell the land. At what point in time does that land, is that theirs to really sell? It depends upon how that land was gifted to them. That could be fee simple determinable or subject to condition, where if they stop doing what they said they were going to do, the land reverts back to heirs because they stopped this condition of making it a conservancy or nature preserve or something like that. So that's how we look at the feasible fees and how is it going forward. How long does somebody have the right to use it that way when there's conditions tied to it? Life estate is an estate measured by somebody's life or lives. A life tenant has ownership interest in the land which may be sold, mortgaged, or leased, but the interest is not very marketable because it's only for their lifetime. I had a life estate, and it connects to the Moorline family, the Moorline beer family that we hear about Moorline beer today. In Fairfield on Port Union Road, years ago, that was part of the Moorline land where they grew the crops for beer. And Mrs. Moorline, this was in the early 90s, Mrs. Moorline had remarried. Her husband died. She remarried her second husband, and she died, but she gave him a life estate to be able to live on her land until he died, or went to a nursing home. And then at that point in time, the land would revert back to the Moorline family. So as long as he was alive, he could live there, use it, and the trust paid the real estate taxes, and we had tenant farmers take care of the land and make it continue to keep it profitable while he lived there, but we took care of the house for him. But the whole thing about being marketable is if he died of a heart attack tomorrow, obviously the land reverts back to the estate tomorrow. But he could live for 10 years, and he did. He lived for quite a while, but when he moved in a nursing home, then the land reverted back to the family. So that's why we're saying it's not very marketable. We did do lease. We did tenant farming on the land. So that worked. But again, it's all dependent upon his life. The life tenant cannot waste the land. In other words, they have to make sure the taxes are paid, utilities are on, that they're preserving the buildings on the land or doing something to maintain and take care of the land. That's the not waste piece. The dower. Dower rights is a life estate of a widow in 1/3 of any real property to which her spouse had legal title during marriage. Dower rights, or courtesy rights, is the male for the female, and we kind of eliminated the whole courtesy piece. We call it dower rights today. So anytime people get married, they inherit something called dower rights, which means that if their spouse dies, they have dower rights and they have a claim to 1/3 of the property. This is one of the reasons the gay and lesbians are saying, wait a minute, we deserve to be recognized in our marriage in any state so that we get this thing called dower rights. So that if something happens to our spouse, we have a right to become property owners or to become owners of part of the estate of that person who was our significant other. It's fair. It's equitable when we think about it. But when we don't recognize those rights, we lose those rights. A future estate is an interest in an estate that may become possessory in the future. So future interests often restrict the use of land to the detriment of owners of present and future interests in the community. And states have passed laws that limit a future interest can last, and laws to limit the time during which the future interest can be enforced. And I'm thinking, in my career in real estate, I really didn't deal with a lot of future estate issues. I had a lot of experience in the trust department where I dealt with the life estates and things like that, but we really didn't have a lot of future interests. When we did coal and mineral rights, they were future in the fact that you would sign a lease for 10 years, 50 years, or something like that, but they had an expiration date on them. And even though it was in the future, it had a specific expiration date. And that's it for this lesson on estates.